Hello everyone, let's begin today's video with the topic titled Establishment of other High Courts and Supreme Court. In the previous video, we saw that how the Federal Court was set up in India by virtue of VIII Act and how it paved the way for the Supreme Court of India to be established in 1950. Now we will come on to the High Courts. After India attained independence in 1947, Constitution of India came into being on 26 January 1950. Everybody knows that. The transition from Federal Court to Supreme Court of India, that is in short written as SCI, was seamless. Justice Kania became the first Chief Justice of India. Always remember these firsts. जो भी first person होता है ना कोई काम करने का, that itself becomes a very important point. It is very important question of legal GK or simple GK it can be. So you need to remember it, underline and learn this, that who was the first Chief Justice of India. Chief Justice of India as in the first Chief Justice of Supreme Court of India after independence. Okay, so Justice H.J. Kania is his full name. It is often said that Supreme Court of India exercises jurisdiction far greater than that of any comparable court in the world. So now that means there is Supreme Court of India, there is Supreme Court of USA, right? So these are the parallel courts. Supreme Court of India is at the same level as that of Supreme Court of US. So these can be compared, the comparable level of court in the world. So in that case, Supreme Court of India has the greatest jurisdiction that any comparable court of the world can have. Original Indian Constitution envisaged a Supreme Court with the Chief Justice and 7 puissant judges, while empowering the Parliament to increase the number of judges. So that means when the Constitution of India was established at that time, the framing of Supreme Court as a body and what all membership that it will have, that was given to be as 7 judges plus 1, that is Chief Justice. That means there will be 7 junior judges and the senior most judge would be the Chief Justice of India. So this was the original constitution. That means जब सबसे पहली बार कॉन्स्टिट्यूशन बना और उसमें सुप्रीम कोर्ट को मेंशन किया गया, तो एज एन ऑर्गन सुप्रीम कोर्ट वर्क करता, तो उसमें कितने मेंबर्स होंगे, उसकी मेंबरशिप क्या होगी, उनकी क्वालिफिकेशन क्या होगी, वो सब भी मेंशन्ड था. और मेंबरशिप में था 7+1 का रेशियो. दैट मीन्स रेशियो नहीं, 7+1 नंबर. दैट मीन्स 7 जूनियर जजेस एंड 1 चीफ जस्टिस ऑफ इंडिया. प्यूसन मीन्स junior. And the power was also given to the Parliament that if you feel like with time you may increase this number of judges from 7 to anything that you want. Subsequently, Parliament increased the number of judges to 12 in 1956, 14 in 1960, 18 in 1978 and 26 in 1986. Now, if I talk about the present day scenario, this number has further increased to 34. Now, you need to find out in what year this had took place, and 34 means 33 plus 1, 33 junior judges and 1 Chief Justice of India. When I write 33 plus 1 or 7 plus 1 means that plus 1 means the Chief Justice. Total judges are 34, 33 plus 1. Okay. The number of judges in Supreme Court was increased to 30 by virtue of Supreme Court Number of Judges Amendment Act 2008. Judges generally sit in smaller benches of 2s or 3s and form larger benches of 5 or more only when required to do so, or to settle a difference of opinion or controversy, like it happened in the Ram Mandir case, right? Ayodhya matter, Ayodhya temple dispute, and the RTI matter that I gave you the example of in the previous video or in this video, whatever. And if there is any such a substantial question of law or a controversy in which it may happen that there is a difference of opinion between two or three people, so we see that what is the majority opinion, and that obviously forms the verdict. 3:2 का अगर जजमेंट है, 5 जजेस हैं बेंच में, और 3 जजेस agree to a thing and 2 judges agree to another thing that may be opposite to this verdict, so obviously majority wins as we say. So इनका जो verdict होगा वही verdict माना जाएगा. अयोध्या केस का verdict unanimous था, 5:2 रेशियो था. All the 5 judges, the bench was of 5 judges, and all those 5 judges have agreed to the point that there would be a temple at that place, and there was 0 judge who could disagree to this fact. So that is how. And whenever, see, generally it happens that there is 1 judge bench or 2 judge bench, 5 or more, and that happens. Now see, when you have to frame or when you have to set up a larger bench, that happens in odd numbers, 5, 7, 9, 11, 13, like this way the bench sits, odd numbers, alternative odd numbers में बैठते हैं. So if there is a 5 judge bench case that has been reappealed in the same Supreme Court, then it may happen that now अब 5 judges bench थी जो कि satisfy नहीं कर पाई, तो अब इससे ज़्यादा बैठेंगे, 7 बैठेंगे. 7 नहीं satisfy कर पाई तो 9 बैठेंगे. तो जितने पहले बैठते हैं उससे ज़्यादा अगले टाइम बैठाया जाता है. ठीक है. एंड ये बेंचेस जो डिसाइड करती हैं कि कौन सा जज किस मैटर पे बेंच में बैठेगा, दैट इज़ बाय द चीफ जस्टिस ऑफ इंडिया. वो कौन डिसाइड करता है? चीफ जस्टिस. The Supreme Court has a threefold jurisdiction. As a federal court, it has exclusive original jurisdiction in any dispute arising between the Government of India and one or more states, between Government of India and any state or states on one side, and one or more states on another, or between 2 or more states. So that means if there is a dispute between state 1, state 2, union government and a state, let it say state 1, or a group of states and union government on one side, so in that matter, all these situations, the court has original jurisdiction where it can directly deal with these kinds of disputes. Then see, threefold jurisdiction means 3 types of jurisdiction. First is exclusive original jurisdiction. Second one is appellate. As an appellate court, that means the lower level courts can if the person is not satisfied with the verdict of lower level court or high court or district level court, then that can, as an appeal, that matter can go to the Supreme Court, because it is the highest court of appeal or the apex court of law in India in present scenario. Supreme Court can hear appeals from state high courts on civil, criminal and constitutional matters. So its jurisdiction is very wide on each and every kind of matter, whether it is civil or criminal or constitution, it can hear the cases. Supreme Court has also a very wide appellate jurisdiction in as much as it has the discretion to grant special leave to appeal under Article 136 of Constitution from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in territory of India. So remember which article? Special leave. This is known as special leave petition, SLP in short, which means that this statement means that by virtue of Article 136 of Indian Constitution, Supreme Court has an appellate jurisdiction wherein it can also, now see, this is special leave petition. That means if a person does not want to go, see, what is the hierarchy? District level court, high court and Supreme Court. But if there is a person who doesn't want to go to high courts after dissatisfaction of the verdict of district court, he doesn't want to appeal to the high court, he wants to directly appeal to the Supreme Court. Okay, so if, see, you are leaving one station, that means you are leaving this station and you are directly heading over to this one. So that means you are taking leave of this particular court of law. So that is known as leave. And since these are in special cases, you have to give suitable and reasonable reasons that why you are appealing directly to the Supreme Court and not to a lower level court. So you have to give a special reason for that, or a reasonable valid reason that why you are doing so. So that is special leave petition. Petition means filing any case, that is petition. So that's why this whole scenario is known as special leave petition, SLP, which is in Article 136. So this is a sort of special leave for an appeal that the Supreme Court has. So generally appeals are from district court, high court, then matter goes to Supreme Court. That can happen. From high court to Supreme Court appeals can happen, but directly if it is happening leaving one station behind, that means it is SLP with a valid reason that you have to grant. Okay, and it can be verdict that is passed by any court of law. In India, in addition, Supreme Court hears a number of statutory appeals provided under separate legislations. Supreme Court has a special advisory jurisdiction in matters which may specifically be referred to it by the President of India under Article 143. That means, as Federal Court exercised the advisory jurisdiction and it had the power to advise or to suggest the Governor General at that time in some substantial questions of law. So as the President of India can, if he wants or whenever he wants for a question of law or for any matter, he may refer to the Supreme Court of India for a suggestion, and that can be done by virtue of Article 143 of Indian Constitution. Wherever the articles are coming, you have to learn them. No other way out, no other option you have to learn them by heart. What article says what? Article 136 is special leave petition in short, if I say, and Article 143 is advisory jurisdiction of Supreme Court, who ask for the advice the President of India. Further, the Supreme Court has concurrent original jurisdiction along with High Courts for enforcement of fundamental rights under Article 32. The matters that directly file up to the Supreme Court, and if it's through the writ petitions that are there, writ petitions, I told you 5 writs are there in India, 5 writs that can be filed. So if it is through writ jurisdiction, that is by Article 32. So there are in this one paragraph we have taken over 3 articles related to the Supreme Court. The jurisdiction of Supreme Court can be enlarged by Parliament, means the jurisdiction, if the Parliament wants, it can extend the arena of Supreme Court. The Supreme Court may pass any decree or order as may be necessary for doing complete justice. Now, this complete justice or this power is mentioned in Article 141 of Indian Constitution, and this was recently used in that Ayodhya temple case, wherein to grant complete justice by invoking Article 141 of Constitution of India. Both the parties to the suit, they were granted some acres of land to construct their own places of worship, right? So that was for doing complete justice, means there is some special power that any order, any verdict can be given by the Supreme Court just for the matter of conveying justice, complete justice to the people. And this is by Article 141. The law declared by Supreme Court shall be binding on all courts within the territory of India. More importantly, Supreme Court exercises judicial review, means whatever verdicts it had given earlier. Review means to view again. If there is an earlier verdict and it is filed for a review, that means you hear the matters again, so that if there is a mistake you can correct it. Review हम क्यों करते हैं? We revise or we क्यों कहते हैं कि whenever you give an examination, just revise or go through once what you have written, so that you may catch up with your mistakes and you may correct them, so that you don't lose marks in the paper, right? It is said no. So similarly, those judges are also human beings. They may have interpreted a constitutional provision or any other rule book in an arbitrary manner earlier that is not considered correct as per the current scenario. So in that situation, they view an old case again, that is known as review. And since it is happening in judiciary as an organ, as an institute, so in all it sums up to the term which is judicial review. You just need to know the meaning of this term at this level basically. Further judicial activism and judicial review that you will do later on. So, judicial review power. Now, also with this, there comes a question that since we have borrowed various provisions of constitution from various other countries' constitution, so now you will search that from which country we have taken this principle of judicial review, this system of judicial review rather. So, judicial review means the power to strike down or declare unconstitutional both legislative and executive actions which are contrary to provisions of constitution or violative of fundamental rights guaranteed by the constitution, and also on distribution of powers between union and states. Means if any legislative or executive action is going against any of the principles or provisions which are written in the constitution, or which is going against any of the section or provision of the rule books or the acts which are in place at that time when the verdict is being delivered. So if that is going contrary to the constitution is the most supreme body, right? So if it is going against the constitution, then you can review that matter. आप उसको फिर से देख सकते हो, so that if there is a mistake you can correct it. Going contrary to the constitutional provisions is a mistake. To correct that, you have to listen to the matter again. That means you have to review it. Since it is happening in judiciary as an organ in the Supreme Court, so that is termed as judicial review. I hope this thing is clear. Now, from here, next video. Thank you.